So good morning, friends. Time to start for the day, and not many people have joined on time. That is the problem with the Indian traditions. People don't come in time, and this is one reason why people suffer throughout the life. No discipline. Let me tell you the basic of success in life, and that is called discipline. If your friends and your colleagues cannot be here on time, means they cannot be there anywhere at time. It's their choice. Let us continue with what we discussed last time. We started, or rather, we ended the session when we were talking about the notice. So, in the beginning of the session today, I will give you a brief of the notice in the form of a chart so that you can use that for drafting the resolutions again and again. Okay? Now I'll give you what is there in the notice. So that will be on the board. So we'll stop sharing for the time being and coming to the whiteboard. Okay, so time to go for okay, I'm going. So here, I don't know whether you can see full screen or not. Can you see full screen? Okay, okay. So here comes the notice of general meeting. How do I see full screen? So, okay. In the notice, mainly three things are there. One is the main part, and another we especially talk about explanatory statements. In the main part, you may be asked to draft a resolution or rather complete notice either in this paper or some other paper, but this can be there. This is about name, registered office, UID. Then comes the most important part. Type of meeting, date, time, and place. Then comes agenda. In agenda, you have to talk about ordinary business and special business. After the agenda comes notes. In the note, the most prominent one is about proxy. There can be other things as well, but the most important thing is about proxy. Okay. Explanatory statement, I had already given to you what are required to be contained in the explanatory statement. And number one is brief of subject matter. Brief of subject, then applicable provisions, type of resolution, interest of directors, and key managerial personnel. So this is in nutshell. Can you see the complete board? I cannot see whether it is, you can see the full screen or not. Is it a full screen? Where is the problem? Is it there? Okay, okay. Take note of it so that we can go ahead fast. Nikhil, can you transfer the hosting? Daytime place. DTP stands for daytime and place. You were not there in the last one. DTP stands for date, time, and place. Is it done? See, once you know the content, what is to be written, where it is to be written, then it is very easy to draft the notice. Or rather anything. Same thing I did about the resolution. I gave you a sequence in which you have to write. Okay. So this is about the notice. And now we are going back to further the material. And let us start. Notice of the meeting. So this portion we have already completed. So this is I was discussing about explanatory statement where we to stop. Subject matter, the difference of the provision, background of the subject matter, the type of resolution required, and interest of directors. That is what is I have already mentioned on the board once again. Okay. Now we come to the important provisions, and this is about quorum in the meeting. Now you have to understand what is the meaning of the word quorum. Quorum is required for two purposes. One is for commencement of the meeting, and number two for transacting the business in the meeting. Now the difference for quorum in the general meeting and quorum in the board meeting. In the general meeting, quorum is required only at the time of commencement of the meeting. Once the meeting commences properly and thereafter whether the quorum is there or not does not make much of the difference. Meeting continues. But in case of board meeting, quorum is required for commencement and also for every subject matter which is transacted or conducted therein. So there is a difference in quorum for general meeting and board meeting, and this provision section 103, this is about general meeting only. The title should have been corrected, quorum for general meeting. Add the word general meeting. Okay, otherwise this will confuse you. And as I said, so once again, I'll draw a small chart only for making out a difference. What is quorum? And quorum is quorum means minimum presence required. Now, quorum for general meeting, we are talking here. In for board meeting, we will talk when we come to the directors section. In the general meeting, act will always supersede. In the general meeting, quorum is required for commencement of the meeting. And the board meeting, quorum is for commencement and also for transacting every business. In general meeting, generally only members. There are cases where the quorum, when the proxy can also be counted for quorum, but generally only members. In this case, only directors, that too, disinterested directors. So there are differences in the quorum for the purpose of general meeting and quorum for the purpose of board meeting. I hope the difference is clear, right? So this is a very common problem which arises when we discuss the two things without understanding the difference. You start applying the provisions of general meeting in the board meeting and provisions of the board meeting in general meeting. Lots of confusion arises. That's why I give you clarity that there is a difference for the purpose of general meeting and for the board meeting. Is this basic difference clear? Okay. Then in the general meeting itself, we can continue further. You can write down below this. In the general meeting, again you can write for company having share capital, company not having share capital. Okay. So when we read, you can continue writing in this chart itself. Okay? So here comes the provisions. So here you can write, in case of this, you can bifurcate again in two parts, private companies and public companies. In case of public companies, depending upon the total number of members, a distinction has been made what is required for the purpose of quorum. So 5 members personally present if the number of members as on the date of meeting is not more than 1,000. Now, this language has been confusing since I started studying company law more than 30 years back. So, these 5 members, whether we are talking about eligible to vote or not eligible to vote, whether joint holders will be counted or not counted. So, these questions are always there. And I thought that in this law, they should have been, or rather in the new act, that should have been clarified, but by chance the language remains same as it was in the Companies Act 1956. So 5 members personally present. If the number of members in the company does not exceed 1,000, it becomes 15. If the number is exceeding 1,000 but not exceeding 5,000, it becomes 30 if the number of members are exceeding 5,000 members. So any listed company, the chances of members being less than 5,000 is very, very less. In case of private company, 2 members present personally. Right. So this is where the difference comes. And in case of public company, you can apply depending upon what is the number of members. So that will remain same. Okay. So this is about the number of members in the quorum. And then comes what happens if the quorum is not present. So here I had mentioned earlier that quorum is required only for the purpose of commencement of meeting. After commencement, whether quorum is there or not, that is not very important for us. Subsection 2 says, if quorum is not present within half an hour from the time appointed for holding the meeting, then what happens? The meeting stands adjourned. Underline the word, write boldly in the notebook that the meeting gets adjourned. The meeting does not get postponed. The meeting gets adjourned. Now that depends upon who has called the meeting, whether meeting is called by the board on its own or meeting has been called on a requisitionist. If it is called by requisitionist under section 100, the meeting gets dissolved if quorum is not present within half an hour. Okay, so got this? So now I can add further things on the board for you. What is quorum? What is the effect of quorum not being present? So if the quorum is not present within half an hour from the appointed time, the meeting gets adjourned. Adjourned means for the purpose of law, the meeting has begun. By chance, by mistake, if you use the word meeting gets postponed, your answer, if I am the examiner, whole answer goes wrong. There is a substantial difference in the wordings used. So meeting gets adjourned. Adjourned means there is a deemed commencement. So for the purpose of law, the date of original meeting only will be considered for every purpose. Right. So when the adjourned meeting should be held, for that the provisions are further given. This says the adjourned meeting preferably on the next week, same day, same time, same place, where the board has been given a right to decide another date, another place, and whenever this happens, 3 days notice has to be given. So if there is any change, either in the date or time or place, because prima facie requirement is when the meeting gets adjourned automatically in this manner, The adjourned meeting should be held on the same day, same time, same place in the next week, but that should not be a public holiday, right? And by chance, if the board decides to hold the adjourned meeting on some other day, some other time, some other place, or in any, they choose some other things, then that is also possible. But whenever there is a change of any type, either day or time or place, then minimum 3 days notice is required to be given. And that notice may not be given individually, if it is good enough if it is published in the newspaper, and the newspaper one is in English and other is in the vernacular language. Once that is published, that should be considered as good enough notice. But 3 days notice is required if there is a change. And in the adjourned meeting, if the quorum is not present within half an hour from the time appointed for holding the meeting, the members present shall be the quorum. Now, this subsection 3 has been a subject matter of legal issues in the previous company law. So, whether one member can form a quorum, question is, when the meeting gets adjourned because of lack of quorum, in the adjourned meeting only one member is present, can that be considered as a quorum? Answer is no. Right? Reason already given. This number is talking about plurals, it is not in singular. Right? This is the reason that minimum 2 members are required for the purpose of quorum. But exception is there. Only one exception where single member quorum can be there, and that is when the meeting is ordered to be held by the tribunal. In the AGM also same provisions. And for extraordinary general meeting also we had same provision. That when the meeting is ordered by the tribunal can also provide for a single member quorum. And that we have already studied. So except where the meeting is ordered to be held and conducted by the tribunal, minimum 2 persons are required for forming the quorum. We have already seen that depending in case of a public company, depending upon the number of total members in the company, the quorum is either 5 members or 15 members or 30 members. In case of private company, minimum 2 members. And generally, quorum is always personal presence of the members. The proxies are not included. But proxy can be included in quorum if ordered by tribunal. Otherwise, no. Do you have any question on quorum? We can discuss that and then proceed further. Any question? On quorum? If the quorum goes below minimum requirement during the meeting, that does not affect the meeting. Meeting continues. In the board meeting, meeting will not continue if the quorum is not there, but in the general meeting, quorum does not affect the continuation of the meeting. Next question. When proxy will be counted? Proxy will be counted only where the meeting is ordered to be held by the tribunal. Okay, I'm taking you back in the material. Just wait. See here. So some technical issue and this kind of problems may be there once in a while, and let us be ready for these things. Okay. So once again, going back to sharing and what we will do. So I was talking to you that why the chairman is required for the meeting. So chairman is required for giving a direction to the board, the meeting. And we will see that he declares the result and the declaration made by him is final unless something else is proved in the court of law. So very important role of the chairperson. Actually, the title is wrong. It should have been a chairperson rather than chairman. Okay, so these kind of problems are there in the law. Anyway, it doesn't make a difference. So here it says, unless the articles otherwise provide, the members personally present at the meeting shall elect one of themselves to be the chairman thereof on the show of hands. So what the message is being given here in that for every meeting, a chairperson shall be elected then and there, but this is subject to articles having any specific provision. It means in this section, the articles have been given an overriding effect over the act. And generally provisions contained in the articles are the chairman of the board of directors will also be the chairman of the general meeting. Next provision says that if chairman is not present within the fixed time of 10 minutes, 15 minutes, then another director present may be elected to be the chairman of the meeting. And if none of the directors are also there, then comes this provision that any member, or rather one of the members present, should be elected as the chairperson of the meeting. Right. So this is the one section where articles have been given an overriding right. And the right is that if the provisions are contained in the company's articles for appointment of chairman of the meeting, then first of all, that will prevail. And if there is nothing, only then this will be relevant. Okay. Now, subsection 2 says that by chance if a poll is demanded for the election of chairman. Now, without chairman, meeting cannot proceed. And by chance, if there is a demand for election of chairman himself, then first of all, elect the chairman, then only meeting will proceed. So in that situation, the poll shall be conducted immediately. In all other subject matters, if the poll is demanded, the poll is to be conducted within next 48 hours. But this is one question on which poll has to be conducted immediately. Okay. So this is about the chairperson. So if you have any question about the chairperson, we'll talk about. Otherwise, we will go ahead. So now the chat is on and I'm just seeing it. So if you have any question about the chairman or chairperson, we can talk. Are you listening me? Every meeting the chairperson gets elected. Is there the case law about this and adjourn meeting is required to do? Yes. So if the case laws are there, certainly do those. And quoting the case laws is a value addition. I call them cosmetic value. So what happens if makeup is not applied and what is after the makeup? So these are like makeups. Cosmetic values are there for the case laws. Yes, chairperson can be elected for every meeting separately. Term of appointment, that is only one meeting. Procedure for appointment, there is nothing like a procedure. Procedure is given in the article. Articles are carrying a preference over the act. And that is being said that first is chairman of the board will preside over every general meeting also. is not available within 15 minutes, then one of the directors should be elected as chairperson. If none of the directors are available or they are not willing, then members present may be elected. So there is nothing like procedure for election of the chairman. Any other question? Chairman of the board, that is elected, that is in the board meeting, so not here. That is generally pre-elected. Next. If the article bar any poll regarding chairman, no anything contrary to law is void in the articles. Anything contrary to law contained in the article shall be void. Section 6 is applicable. Anything contrary to law in the memorandum, article, resolution, contract, document shall be void. Vedant, are you listening? Can independent director can also be the chairman in the general meeting? Yes, he can be. No prohibition. If you joined late, that is your loss. Articles can give only who will be the chairman. There cannot be prohibition on a, as far as poll is concerned. That is a statutory provision. You can fix who will be the chairman. You cannot say that members cannot demand poll for the election of chairman. No, name is not required to given in the notice. So, okay. We move to the next part. Now comes the proxies, and proxy means what? In your college, you must have done that many number of times. Somebody has acted as your proxy for the purpose of attendance, and same thing is here. You can appoint a proxy. Now, proxy is an individual. Let me give you some specific definition of proxy. I'll write on the board that will help you. Okay. So here. Proxy. Let me stop sharing so that you can see the complete board. The proxy, an individual appointed by another individual member or members, joint holders can appoint. So an individual appointed by another individual member of a company having share capital. Company having share capital who is entitled to attend and vote in the meeting, to attend the meeting, and vote on his behalf. This is the formal definition of the term proxy. This is not in law, but this is grown over a period of time. So first of all, only an individual can be appointed as a proxy. Who can appoint? Only another individual can appoint a proxy, right? For that you can take another note. A body corporate cannot appoint a proxy. So who can appoint a proxy? Only an individual. No, where you have to write general meeting, mention specifically general meeting, don't mention meetings only. Okay. So an individual, a body corporate cannot appoint a proxy, right? Then further, it can appoint a representative and representative can appoint proxy. So take a note of this. Body corporate cannot appoint a proxy. Body corporate can appoint an individual, and that individual representative can appoint a proxy. So here I was talking about only an individual can be appointed by another individual member. But then is, in case of company having share capital, this is a statutory right. In case of company not having share capital, this right can be given only by articles of association. In case of company having share capital, this is a statutory right. Then the person, the member, he should be entitled to attend and vote at the meeting. Not only entitled to attend, he should be entitled to attend and also to vote at the meeting. Like preference shareholders, being a member, he can attend the meeting, but he cannot vote on every resolution. So who can appoint a proxy? Only a member who's having a right to attend the meeting and also to vote at that. What for? To attend the meeting and vote on his behalf. The purpose is, yes, proxy can be any individual. The proxy need not be a member. Right? So here we can add that sentence. Any individual whether member or not can be appointed as proxy. Right now, just listen what I'm talking about. There are a lot of discussion to go. Okay, so here I have just defined proxy and salient features about that. An individual can be appointed as proxy. An individual member can appoint a proxy. The member who is appointing a proxy should be of a company which is having share capital. And this is a statutory right. Okay, you can add further. Right to appoint a proxy is a statutory right. And a declaration of this right should be made prominently in every notice of general meeting. A declaration of this right should be made prominently in the notice of general. Okay, now balance we will see in the provisions. Have you taken note what I have written on the board? Okay, so let me clear this and continue with. So I'm not comfortable if I don't have a board to write. I must have a board, then only I can teach properly. Can minor become a proxy? Yes, it is your decision to whom you want to appoint a proxy. Ultimately, he is there to vote. Now the video is missing. Meenakshi is complaining that video is not there, only audio is there. Is it clear for all or the same for all? Can you see the video and audio both? Okay, okay. So we go back to sharing and then we will discuss the statutory provisions, what we have. So here we come back to the any member of a company entitled to attend and vote at a meeting shall be entitled to appoint a person as a proxy to attend and vote at the meeting. So what is missing here in this subsection 1? It is not saying that only individual member can appoint a proxy and only individual can be appointed as a proxy, but that I have already given you on the board. Okay, and the purpose of appointing, you see the first line, they say member of the company entitled to attend and vote. This I have already included in the definition. What for? To attend and vote on his behalf. Now, proxy shall not have the right to speak at the meeting and shall not be entitled to vote except on a poll. So as far as statutory provisions are concerned, will not have a right to the opinion of the member on whose behalf he is attending the meeting. He is there only to attend and vote. And voting also, the statutory right is only in case of poll, but through the article, the right can be given to the proxy to vote even in case of show of hands also. In the general, proxy does not have a right to vote in case of voting by show of hands. But through articles provision, the powers can be given so that they can vote even through or show of hands. Provided further, articles of the company otherwise provide this subsection shall not apply in case of company not having a share capital. So this is only in case of company having share capital. In case of company not having share capital, generally companies are the companies not generally. There is no statutory right to appoint a proxy. In case of company having share capital, member to appoint the proxy, it is a statutory right. But in the case of company not having share capital, this is not a statutory right of the member. So you can appoint an existing member also as your proxy to vote so that he can vote in the case of poll. So in case of poll, he will be voting for himself as well as a proxy, right? So I'll point out the difference of voting in the day itself. Provided further, central government class, forget this. So provided also that a person appointed the proxy shall act on behalf of the member or number of members not exceeding 50 and such number of shares as may be prescribed. So one individual can act as a proxy for how many members? Up to 50 members, one individual can act as a proxy. Why this provision? You may not be aware about the history of this kind of provision. Let me give you the background of this provision. Why this is made this way. Long time back, I think that year of 91, 92, rather no, even before that, Dhirubhai Ambani tried to take over L&T. He had acquired a good number of shares in the company L&T, Larsen and Toubro. And there were a number of directors who were opposing member of the board. So he ran a move. He tried to proxies from unlimited number of members of that company throughout India in his favor. So one acted as a proxy for thousands and thousands of members in the general meeting, and ultimately decision was in his favor. Okay, so to restrict that kind of scenario, this is the provision incorporated. One individual can act as a proxy for not more than 50 individuals. A statutory right is that he can vote only by show of hands, but articles may authorize him to vote by show of hands also. Why the right is restricted, that you have to understand. That in case of voting by show of hands, one individual is one vote. In case of poll, one share is one vote. In the right to appoint proxy is not restricted to one unless the articles are saying. Articles can restrict the right that one member can appoint only one proxy, and then the right can be given to him to vote in case of show of hands also. But if he is having the right to appoint more than one proxy for him, and in case of vote of shares, vote show of hands, it is one person, one vote, then there will be a problem. Articles will have to have provisions that one individual appoint one proxy only, and then can give the right to the proxy that yes, he can vote by show of hands also, not prohibited by law. So in law, what is given, that is minimum. Right. So here is the one, if only one member has given a right to act as a proxy for all the members, what will happen? The quorum itself will not be there. Problem will arise there. So for holding the meeting, we need minimum number of members for the quorum, and once quorum is there, then we can have the discussion, right? Then if one person is acting as a proxy, it's good enough. So once the meeting commences, for every subject, he demands a poll because he is the only person acting as a proxy for all, and then he votes and every resolution gets passed. Can restrict the proxy shall act for a single member. No, you cannot go contrary to law. Here it says the member can act, one person can act for not more than 50 members. You cannot restrict that. Okay. So here, subsection 2, this is every notice calling the meeting of company which has a share capital or the article will provide for voting by proxy at the meeting shall appear with reasonable prominence a statement that a member. So this is proxy cannot appoint another proxy. His right is only to attend and vote at the meeting. Right to appoint a proxy is, or rather, authority to appoint a proxy is a right, and the proxy does not have that right. You see, the language itself is very, very clear. The proxy is having right to attend and vote at the meeting, no other right. He doesn't have any right before the meeting, he doesn't have any right after the meeting. His rights are only during the meeting, and proxy is appointed before the meeting. That's why proxy cannot appoint another proxy. Preeti, is it clear? Okay. So the right of a member to appoint a proxy should be mentioned prominently in notice of general meeting. So format of the notice I have already given, and by chance, if those who have not seen the notice of AGM or notice of general meetings of the company, they should log in to and Google the notice today itself. Read some notices, and you will always find after the signature, after the agenda, after the signature, the first note appearing, that will be every member entitled to attend and vote the meeting is also having a right to appoint a proxy. So if the member reaches a proxy, the appointment of proxy gets invalid. Proxy can attend the adjourned meeting also. He is appointed for the meeting, and adjourned meeting is a continuation of the original meeting. So those who have not seen the notices, please Google and read some notices. It will become more clearer to you, right? So when I was studying, we had to visit the companies, request the secretary there to show us something so that we understand clearly what is required. As of today, you don't have to go anywhere, just Google and you can see the notices, right? By chance, we have limited sessions, otherwise I would have shown you here itself what is the notice. And subsection 3 says our default is complying with subsection. Simply declaration in the notice of the general meeting that member is having a right to appoint a proxy, that itself becomes an offense. If article provide can proxy can vote by show of hands, answer is yes. You can give additional rights, you cannot limit their rights. So any provision contained in the articles or of a company which specifies that it requires a longer period than 48 hours. So how long before the, now the question is how a proxy is appointed. So for appointment of a proxy, a formal document has to be executed by the member, and that is required to be deposited with the company before the meeting and not more than 48 hours before. Right. That continues to be valid. Your entire AGM cannot be virtual. This is a temporary phenomena. Special rights are given by law. It is not a permanent feature. So here when the notice, when the instrument of proxy is required to be deposited with the company, it is not more than 48 hours before. So 48 hours time before the meeting, that is the time required by given by law. You cannot by making the provisions in the articles or giving the notice in the notice that proxy should be deposited 96 hours before the general meeting. No. Up to 48 hours you can make. You can reduce the time. You can say 40 hours, you can say 30 hours, you can say 24 hours, you can say 5 hours, you can say 2 hours. Less than 48 is everything is okay. More than 48, those provisions will become void. 1 rupee. Any transfer of right requires a stamp duty. So that is a kind of a stamp duty paid. So any provision contains of which requires more than 48 hours, and what is the provision? Invitation cannot be given to appoint a proxy on company's expenses. You can do it on your own. The instrument should be in writing, signed by the office person. An instrument is to be deposited with the company with time. Number 8 says that any member who is entitled to appointed vote at the meeting is also having a right to appoint to check the number of proxies already appointed. And but for that he is required to give a 3 days advance notice in writing. So that was about proxy. Any more questions on proxy we can discuss, and then we will go on voting rights. So right now I'm keeping the chat open for your questions. Members appointed proxy and delivered to the company and subsequently appointed another person as a proxy, and which proxy is valid? The proxy executed last. That will automatically have the effect of invalidating the previous proxy. Board meeting is not being discussed there. The directors cannot appoint a proxy. Proxy is not counted for the quorum unless directed by the tribunal. Quick. Whatever questions you have, you can put it quickly. See, this is one of the most important chapter we are discussing. In the next important chapter will be directors. So I am intentionally going slow. How will a person know whether the proxy be appointed is also an appointed for more than 50%? No, it is. The member will never get to know. Board of directors can appoint proxy for board of directors. Not at all. Only members in the general meeting. If 2 proxies came or the members himself came despite appointing proxy, who will vote? If the member attends, the appointment of proxy gets invalid. That becomes void. A register of proxies has to be maintained by the company who has appointed to whom as a proxy. So you can check on somebody else, somebody out of those proxies only you can. Proxy can vote only by poll. Is there any subject matter where he can vote by show of hands? So only if it is authorized by the article, they can vote by show of hands. Yes, articles can reduce it up to 2 hours before. Articles can say that even prior notice is not required. You come in the meeting with the instrument, that is also okay. You cannot exceed 48 hours. You can reduce the time, right? And I've seen that kind of information being given by the company that proxy instrument need not be deposited in advance. You can come with this properly signed and stamped instrument directly in the AGM. You have to submit it before entering in the meeting, and that will be valid. Can a proxy be proxy for more than 1 member in the same meeting? How his voting will be counted? So in case of voting by poll, it is 1 chair, 1 vote. So any number of members can appoint. Ultimately, his voting will be in terms of number of shares he is representing. Inspection in subsection 8, I've already said that it is register of proxy maintained by the company. If a member should proxies be deposited in advance, prima facie requirement is yes, so that company can maintain a register, right? But where the time is reduced, this will not be applicable. So now restriction on voting rights. The voting rights of a member is a statutory right, and what are the rights we have discussed earlier. I think before 2 lectures, I had made a chart on this voting rights of the equity shareholders, voting rights of the preference shareholders. Equity shareholders can vote on every resolution placed in the general meeting. Preference shareholders can vote only on those resolutions which are affecting the right directly. And due to calls being arrears, voting rights can be restricted, and any restriction of voting right for any reason other than calls in arrears shall be void. That chart I made for you. Same provision is here. If proxy time is reduced by company, let's say 30 hours before AGM, and company accepts a proxy form afterwards, then if you have declared that it should be deposited 30 hours before, then somebody is filing it later, then that cannot be done. That will be invalid appointment of proxy. So voting rights. So in the voting rights we're talking about that, notwithstanding anything contained in the Act, the articles may provide that no member shall exercise any voting rights in respect of any shares registered in his name on which any calls or other sums presently payable by him have not been paid, or in regard to which the company has exercised any right of lien. Right of lien means the shares have been forfeited by the company. Any other amount due means share capital and the premium. So whether any member is already in default in paying the calls, and calls include principal amount as well as premium amount both. First line, it is not first line, it is lien. Lien means the right of the company to forfeit the shares where the member defaults in paying the calls. That is the lien. So company will really taking away the shares and giving it to somebody else. That is called lien. And as long as lien is existing, the member cannot transfer the shares prima facie, except with the prior permission of the company itself. Hmm? So restriction on voting rights, it is saying that except for the calls and arrears and any other amount due from the member in the capacity of member. Member can be debtor as a customer also, but no, that will not apply here. Is this company law is talking about relationship between company and member in the capacity of member. Same member may be associated with the company in number of ways. He may be employee, he may be debtor, he may be supplier, he may be vendor, he may be consultant. Number of capacities of the member can be there, but any other money due from the person in any capacity other than member will not be applicable for the purpose of this section. So where any amount of share capital or premium is due from the member, or where company has already exercised the right of lien in respect of certain shares, then the voting right cannot be exercised. And any restriction or prohibition on exercise of voting right except as per this provision shall be void. Let's see here. The company shall not accept on the ground specified in subsection 1 prohibit any member from exercising the voting right on any other ground. Clear prohibition, and any prohibition other than this shall automatically become void. Why it should become void? Because of section 6. Because of that it will become void. And on a poll taken at a meeting, a member entitled more than one vote on or by his proxy were allowed, or other person entitled to vote for him, as the case may be, need not, if he votes, use all his votes are cast in the same way all the votes he is using. So in case of voting by show of hands, it is only one person, one vote. So either he can say yes or no, no, he cannot change. But in case of poll, he can choose how many votes he wants to cast, because that is one share, one vote. Right. So if he's having say 1,000 votes, what he wants to be 500 votes only, he can do that. There are 3-4 options available. He can divide the shares. Not necessary that all the votes be used where the voting is by poll. So any question on the restriction to voting rights? I'm keeping the chat on. understanding anything contained in this sect, meaning it means what is written in the articles or this particular section will have effect, overriding effect. It simply means overriding effect. Any other question? So assuming there is nothing, so I'm moving ahead. Okay. So voting by show of hands. This is talking about that at any general meeting, a resolution put to vote of the meeting shall, unless a poll is demanded under section 109 or voting is carried out electronically, be decided by show of. There are three modes of voting as of today. It can be by show of hands, and this can be by poll, and number three, there can be an electronic voting. And unless poll is demanded, the subject matter for electronic voting, the voting should be by show of hands only. Right? The primary voting is by show of hands, but if poll is demanded, then this voting will not be valid. With the question like, let me see the chat. Yes, show of hands is actually performed in the AGM, right? And as of today, video recording of the general meetings is compulsory, right? And the purpose is this only, whether voting was actually there or it is just recorded in the minutes. So voting by show of hands. So primary voting in the general meeting is always by show of hands. You understand the difference of voting by show of hands and voting by polls. When we say voting by show of hands, it is always one person, one vote. And if it is voting by poll, so suppose I hold 5 shares of the company, I will have 5 votes on that. Right. So huge difference is there. Suppose one person is holding 10,000 shares and he demanded a poll, and by chance if the poll demand is valid, let's see what is the requirement for the valid poll. So if the demand for poll happens to be valid, then as a show of hands, as voting by show of hands, he can put only one vote, but because of poll now he can cast 10,000 votes. Right. Now see the difference. In total 11 members are present in the meeting, right? 10 members are holding 5 shares each. One person is holding 10,000 shares. Now, if there is a voting by show of hands, these 10 persons who are holding 5 shares each, they will have the effect. The vote will be, rather, decision will be according to their will. But when it comes to poll, what will happen? These 10 people in aggregate are holding 50 shares, and that another individual himself is holding 10,000 shares. So his vote will always prevail. His decision will prevail. So voting by poll can change the result of voting by show of hands. Okay. So voting by show of hands, so we primarily said that unless a poll is demanded and unless it is a case of electronic voting, the voting should be by show of hands. Subsection 2 says a declaration by the chairman of the meeting, the passing of a resolution, otherwise was show of hands under subsection 1, and entry to that effect in the books containing the minutes, that should be treated as final. So whatever is being said by the chairman, whatever is recorded in the minutes book, that should be treated as the final, as if voting actually happened. Something on the chat, let me see what is there in. Yes. So if he is having 5,000 shares, it will be treated as 5,000 votes. So whatever questions you are putting in, I strongly recommend put it public so that other people can also see your questions and my answers, because otherwise they cannot see your question, but they listen my answer. Okay, so better you put the questions also publicly, so they will see the questions also, they will see the answer, they can listen the answer also. That is more beneficial for all. There should, when it comes to see, there should be an option to put it publicly. A person holding 10,000 shares votes only once. Voting is always only once, but depends upon whether it is voting by show of hands or voting by poll. In case of voting by poll, there is a proper paper on which they write how many number of shares they are voting for, how many votes they are putting in, whether the votes is in favor or votes are against. Right. In case of voting by show of hands, again it is a raising of hands, but only one time, either in favor or against. So in all the situation, voting is only once, but number of votes make a difference. Okay. So go ahead. Now, subsection 108 just simply says the central government may prescribe the subject matter for the classes of companies or may exercise the right through electronic means. So that for that you can refer the module or material provided by the institute, which are the subject matter which are to be taken up by electronic voting. Here we come to the demand of poll. This is something very, very relevant. So as I said earlier, that voting can be by show of hands or by poll. So before we go ahead, I'll take a 2 minutes break, have some tea, and then I'll come back. In the meantime, you can read these provisions about demand of poll. Okay, so I'm not switching off the video, but this you can. If electronic voting is given, then there is no need to do voting by show of hands. So this portion read, and I will take an off from my video, read this one, and I'm coming back just having a cup of tea. My chat is on, you can continue. Can you hear me? So I'm going to make a request to the institute not to put these videos on YouTube, so that people are a little bit disciplined and they come here. Should we do that? not to make the videos available on YouTube? What is your opinion? So no one has said anything about this? So some of you are saying that the students are working in the morning or they are engaged somewhere else. So do you think we all are fools here? Issues are always there. These are all excuses. I'm strictly against making it available on YouTube. So now onwards, I will strictly prohibit that nothing is available on YouTube. So if you are working, then it doesn't mean that institute should provide you facility to come later on. To gain something, you must put in something. So I think that from today onward, today will be the last time my video will be on YouTube, but after this, no more videos on YouTube. Hmm? So people take liberty, and I feel bad. It's a very small number of webinars I'm doing. Those who have attended my professional webinars, they know what do I do. I'm putting time, you are putting time, but some people are enjoying, they are enjoying the liberty that I don't accept. Anyway, let us come back and start the video part. Okay, now I'm back. Convenience is also respect. Okay. Online convenience is that you sit at home and attend the lecture. Convenience doesn't mean you can come at any time and attend the lecture. And so the free facility given to you, free should not be misused. Okay. So this is my decision. Now my videos will not be on YouTube. Anyway, so let's stop the discussion. I have given you my verdict that my videos will not be there on YouTube anymore. Hmm. So coming back to the poll part, so here it is, section 109 is saying that the poll can be demanded. Poll is a subject matter of choice. By operation of law, first of all, voting would be by show of hands. Poll can be demanded before the show of hands, after the show of hands. And if the poll is demanded after the result has already been declared by show of hands, then the result becomes invalid immediately. But the result of voting is going to be final. Result of voting by poll, that is always final, that cannot be changed. And in the process of demand of poll, proxy can also be a party. So this is what we are going to see in this section. So what is said here in is, so here, before or on declaration of result of voting on any resolution on show of hands, a poll may be ordered to be taken by the chairman of the meeting on his own motion shall be ordered to be taken by him on demand in this behalf. So who can demand poll? So poll can be asked for by the chairman as well as it can be demanded by the members. So who are the members? Number one, something interesting. So when faculties are ready to help, there has to be a discipline. And I'm a very strict disciplinary person. And if people don't come on time, they don't deserve my help. Okay. So when you look for something, you must dedicate yourself. For gaining something, you have to give something. And what is required here is only a little bit of dedication, only this much of dedication. Be here on time, right? So if you cannot come on time, if you are committed to other things, be committed there. You don't need to pass exam. Exams are there every 6 months. Don't bother about the time. In this current scenario, everybody can make arrangement for the faster internet. And if they cannot afford that also, then nothing, no help is needed. Excuses are always there. There are a number of reasons. I can give you an answer here. Take a note of this. For not doing anything, there are thousands of reasons. And if you really wish to do something, then only one reason is enough. Hmm. Forget this. Okay. So here, so we are closing the chat and no more discussion on this. I'm continuing. And I've been given one more lecture up to 11th. So we'll have on next lecture on 9th and thereafter on 11th. Okay. Anyway, so here in case of company having a share by the members present in person or by proxy. So proxy can also be a part of for demanding the poll. Proxy cannot vote on show of hands, but he can be a party for demanding the poll. Okay. So in case of company not having share capital by the members present in person or a proxy were allowed and having not less than 1/10 of the total voting power or holding shares on which at least 5 lakhs have been paid up, whichever is higher, that can be prescribed. So they can demand a poll. And in case of any other company, by the members who are holding not less than 1/10 of the total voting power, they can demand a poll. So demand of poll can be done before voting by show of hands, during the process of voting by show of hands, as well as after the declaration of voting by show of hands. And if it is demanded after the voting has already been done by show of hands, the result of voting by show of hands automatically becomes void. Okay. And subsection 2 says the voting for the demand for poll can be withdrawn, but only by those people who demanded voting by show by poll. Right. We're not saying the same percentage of people. It is the same people who demanded a poll. So 100 people together, they make a valid demand for poll, and out of that 10 people leave the meeting. Now the demand cannot be withdrawn because the 10 people are not available. So only those people who made a demand, they can withdraw the demand. And when the withdrawal should be there, before the voting by after that, right? A poll demanded for adjournment of the meeting or appointment of chairman shall be taken immediately. So there are only two subjects on which poll has to be done immediately. Otherwise, the time for taking the poll is 48 hours after the poll is demanded. Within 48 hours. So immediate is only two subjects. One is adjournment of the meeting and another is appointment of chairman. For rest all the subjects. For any other subject, the poll should be within 48 hours since it is demanded. So the time is already given. Number 5 says, when the poll is taken, the chairman of the meeting should appoint some member or other persons to verify the validity of the votes and counting of them. So those are called scrutinizers, right? So by chance the name is not given, they are referred as scrutinizers. So they may be members, they may be employees of the company, and the purpose of appointing the scrutinizer is to see the validity of the votes and counting the numbers. Because here the chairman does not announce a result. In case of voting by show of hands, the chairman directly declares a result. The result is, and he says that the resolution is carried or resolution is not carried. Here he will simply declare the number of votes, and the number of votes will be announced by the scrutinizer. Result will automatically be there, whether the resolution is carried or not carried. Number 7 says the result of the poll shall be deemed to be the decision of the meeting on the resolution. So here we this point is to be very clearly understood that in case of voting by show of hands, in case of voting by show of hands, the chairman declares the result. In this case, the scrutinizers declare the number of votes, and that becomes the result. Directors can be appointed as scrutinizers. Answer is yes. The chairman at adjourned meeting of poll should be immediately. It does mean less than 48 hours. Yes. If immediately, immediately. So if you are deciding a subject matter whether to adjourn the meeting or not, and for that also you adjourn the meeting, no. That is immediate means exactly the next moment there should be voting on that subject. So there are only two subjects on which the poll has to be done immediately. Independent person, because there is no question of independence. The question is there members present can be appointed as scrutinizers. And if members are not willing, then employees can be appointed as scrutinizers. The question is who will count the number of votes and validity. That is the question. So that's why some people are required. So directors can be appointed, members can be appointed, employees can be appointed. It is not restricting who can be appointed as scrutinizers. Okay. So let me change the direction here for the chat. So I have shifted the location of the chat on my board. So on demand of poll, yes, I will write it on. Let us complete the discussion first, and then we'll write it on the board. And the result of poll shall be the demand on to be the decision of the meeting on the resolution poll shall be taken. The chair, sir, the chairman and adjournment of meeting should be immediately if it means less than 40 days. Yes, that is what I have already answered. That should be done immediately. As soon as there is a demand, the voting by poll should be done. For any other subject matter, you can adjourn the meeting and then later on in the adjourned meeting, there can be poll. Okay, so now we will have the charts and some other documents as far as voting by poll is concerned. Okay, so be ready with the copy and pen. And stopping sharing. Voting by poll. This reflection of the tube light is there. What can I do? Right now, there is no other arrangement I can make. So what I have written is voting by poll, section 109. So because of reflection of the TV, by chance it cannot be seen. Even if I'm changing the flap, it is not working. Or I can write it again here. This is voting by poll. Okay, can you read it now? So this voting by poll, this is first, it is only on demand. Next is demand should be in the meeting only. Then demand can be before or after voting by show of hands. If demand is made after voting by show of hands, result of voting by show of hands becomes void. Is it visible or not? Meenakshi. Noted? Yes, poll can be demanded even before the show of hands is done. Noted? Very good. Very good. So I want serious people here. Those who are not serious, I'm not available with you. No. Who can demand? Company having share capital and company not having share capital. In case of company having share capital, first option 10% of total voting power or paid up capital of rupees 5 lakhs or higher amount prescribed. Any of the requirements satisfied and they can demand it. In this only one parameter, %10 of total voting power, they can demand poll. Okay. And when we say voting power, that includes proxy also. So here you can write who can demand poll. This is, here you can add members and proxy poll. In case of voting by show of hands, only members can vote unless articles authorize the proxy to vote there also. But as far as demand for voting by poll is concerned, even proxy can also be party for demand of poll. Okay. Now they can demand, and if the demand is valid, what is the effect? Paid up capital is certainly paid up share capital we are talking about. Okay. So once the demand is made, and if the demand is valid, then any vote by show of hands that becomes void. Minority interest is not protected when the demand for poll is there. The company runs by law of democracy. There's nothing like minority or majority. Right? The real democracy is one person, one vote. Some technical issue may be there because others can see the video in minority shareholders. Law does not protect minority. Because in company law, minority is two ways. One is in terms of number of shareholders, another is in terms of number of votes the persons are holding. So whom should we protect? Proxy can vote on poll, yes. Right? So here we will go for further. Voting in poll. Put another title. Voting in case of poll. Number one, if question relates to either election of chairman or adjournment of general meeting, voting shall be done immediately. And on any other subject matter, voting can be done within 48 hours. Means if required, meeting can be adjourned and voting can be done in the adjournment. Okay, so that is the purpose. So where adjournment itself is the subject matter of voting, that has to be done immediately. Point number two. members and proxy both are entitled to vote. In case of voting by show of hands, only members have a right to vote. Unless articles authorize the proxy to vote. But in case of voting by poll, the members and proxy both have a statutory right. Rashmi, you have to say something? Rashmi Divakaran. If you adjourn the meeting, right, and adjournment is beyond 3 days, then notice is required, not before. Namita, others can see. Namita, can you see it clearly now? ओहो, अभी तक वीडियो ब्लैंक ही चल रहा है. What can I do? Others, please tell me whether video can be seen or not. So, those who cannot see the video, there must be some technical issue. Okay, so that you can revise subsequently. Now, coming to point number 3. Number 3. Chairman shall appoint scrutinizers for counting votes and examining the validity. The chairman cannot refuse the voting by poll. That's why, as of now, video recording is compulsory. Earlier, that was possible, not now. The chairman shall appoint the scrutinizers, and the purpose of the scrutinizer is for counting the votes and examining the validity. The scrutinizers announce number of votes, and this itself becomes the result. Number 5. Result of voting is a final. Number 6. Demand of poll can be withdrawn, but only by those people who demanded poll. Who can withdraw? Only those who demanded poll, and that too before voting by poll. Once the voting is done, then there is no question of withdrawal. Okay, so these are few notes on voting by poll, and if anything left out, you can take a note. If 100 demanded poll and 99 want to withdraw, but one does not want, what will happen? It cannot be withdrawn. All the people together who demanded poll, they can withdraw the poll. Even one person make a difference. One person doesn't want, it cannot be withdrawn. There is again a problem in the audio. Okay, so some people are saying there is a problem, some people said there is no problem, and okay. So I presume there is no problem. Network issues do arise, and that's why in the current scenario of 4G, problems may come. We should be ready. If the poll is demanded by the member who hold less than 1/10 of the total voting power, this will happen in case of bigger companies. That's why for the bigger companies, another option is given that they are holding the share capital on which not less than rupees 5 lakhs have been paid up. So if they hold 50,000 shares, 2G had the problem. Yes, 2G certainly had the problem at that time. 2G, 3G, there are problems, but 4G, there are no technical problems. Okay. And those who are watching on the phone, preferably they should not be having problems. Those who are watching on the laptop, they may have problems. Okay. So make prior arrangement when you have to attend a video lectures, and every week I am holding webinars. Is there anyone who attended my Sunday webinar? Is there anyone here who attended my last Sunday seminar? So last Sunday, that is day before yesterday, I held a webinar on time management. And next Sunday, I will be holding webinar about the procrastination. So are you aware of what is called the procrastination? Procrastination is unnecessarily postponing the things, delaying or postponing the activity or the action to be taken for no valid reason. That is called a procrastination. So this program will be about the procrastination, why the procrastination, and how you can win over this. That will be the subject matter. Those are my private webinars, so those are not through the institutes. So you can certainly ask me on my private chat later on. You have my numbers. Anyway, so right now let us go proceed further. I'm going back on the sharing part, and this is here. So postal ballot, this will not discuss because only one question can be asked on the postal ballot. They will not ask you the procedure, and the question will be, what are the subject matter? Postal ballot is compulsory. So all important issues are required to be taken up through the postal ballot. amendment of memorandum, amendment of articles, increasing the borrowing power, then appointment of the directors, appointment of auditors. On all those important issues, postal ballot is required. So that you can, for that you can refer the material which are the subject matters on, right? So this I'm not discussing in detail. Circulation of members resolution. This you may be a little confused. What is this subject matter? Circulation of members resolution. So as a member, if you want to submit any resolution which is to be circulated among other members, then that is possible, that you can do. Okay, how you can do that, that we are talking about, we are going to discuss in this section. So as a member, you can submit two things for being circulated among other members. Number one, you can submit a resolution, and number two, if not a resolution, you can submit any statement about the subject matter already circulated, for which notice has already been given. So this section says the company shall, underline the word shall, it is an obligation of the company, on requisition and writing of such a number of members as required in section 100. Give a notice. So how many members are required in section 100 to requisition? Right. So section 100. Let us go back to section 100 once again and we'll come back here. So this is requisition of extraordinary general meeting. How many members are required for requisition? 1/10 of the such number of the paid up share capital of the company. Those. So they can submit a requisition for resolution. Right. So first of all, this is important. How many people can submit a resolution for circulation? So here in nutshell, you can say that members holding 10% of the total voting power or total 10% of the total paid up capital, they can submit any resolution or a statement for circulation. So in the old law, this was not the requirement, and any member was eligible to submit a resolution to the board for being circulated to the members in the AGM, and that was a problem, serious problem in the bigger companies. Now, because of this requirement, that problem has already been taken care of. Just as the company shall, on requisition in writing, requisition is always in writing under law, right? Requisition is not oral as far as law is concerned. So requisition on requisition and writing of the such member as required under section 100. So how many are required? So those who are holding 10% of the paid up capital or 10% of the total voting power, as the case may be, they can give a notice to members of any resolution which properly be moved and is intended to be moved at a meeting. They cannot give it to the members directly. They have to submit it to the board, to the company, and company will circulate among the members. And number two, circulate to the members any statement with respect to the members referred to in the proposed resolution of business to be held in that meeting. What does it mean? If the company has already decided a date when the next general meeting is to be held, and members who are holding 10% of the capital or 10% of the voting power, they want any specific resolution to be placed in that meeting, they can submit it to the board. And board is under obligation, read line where it says company shall. So if a resolution is submitted by the members who are eligible as per section 100, and submission is made to the board of directors, then board of directors will be under obligation to place the resolution in the general meeting for voting. Actually, the title is wrong. It is not the resolution. It is the proposal which is placed in the meeting. It becomes a resolution after the meeting. Okay. So these kind of technical errors are there, but we have to understand by interpretation of law. So can give a notice of members of any resolution. No, it is not a resolution. This is only a proposal. This can also be referred as a motion, but this is not a resolution because it becomes a resolution after voting in the general. So either there can be a proposal of resolution or there can be a statement. right? So statement and resolution are different because resolution is something new, and the statement is it is in relation to a subject matter which has already been given in the notice, which is already circulated. So therefore, there is a difference in time limit when these are required to be submitted. So company shall not be bound out of this section to give notice of any resolution to circulate that is a statement unless. Now, in case of resolution, when the resolution shall be submitted, the resolution shall be submitted, this is 6 weeks before the meeting, and the statement is submitted 2 weeks before the meeting. Why? Because the notice of general meeting is required to be circulated 21 days before, that is 3 weeks in advance, and statement you can submit after only after receiving the notice, but resolution has to be submitted much before that, because the resolution is going to be a part of the notice. Of first of all, it is received by the company, then board of directors is going to consider that, then it is going to be included in the notice. That's why the resolution has to be submitted at least 6 weeks in advance, and statement after submission of the or after circulation of the notice. So the resolution is 6 weeks in advance, the statement 2 weeks in advance, and when it is submitted, also pay the expenses to be incurred by the company. Then further it is said that where the resolution is submitted, company has to submit. I'm going to explain what is the statement. Okay. Now, where the resolution is submitted and by that time the date of general meeting is not decided, then what can happen? In that situation, if the date of meeting is not fixed and meeting is scheduled to be held within 6 weeks, then it is presumed that the resolution was submitted 6 weeks before. Okay, now I'll draw a chart and simultaneously I will explain the difference between the resolution and statement. Okay, so put the title section 111. Title 111, and we are stopping the sharing and coming back to the camera. Yes, giving you the notes. Have some water. So here, section triple. Members eligible under section 100. So they are 10% of paid up share capital or 10% of total voting power. Can submit any resolution. This is actually proposed to be placed before next general meeting for voting. Number B, a statement. Now this is their opinion. About any subject matter already included in the notice of general meeting already circulated. Now you can make out the difference. A resolution is something new, which is not there in the notice of general meeting. Here, a statement is their opinion. Opinion on any subject matter already included in the notice of general meeting. It means the notice of general meeting has already been circulated. And here, the notice has not gone. So therefore, this is 6 weeks before, and this is 2 weeks before. I cannot see your faces. I can see only comments. Yes, the resolution submitted will be included in the notice. Difference between both. One is a new proposal to be placed in the general meeting. Another is a proposal is already there. You are giving your opinion. Okay, now giving an example. Okay, so let us take an example. For example, a resolution. Say company's articles do not have any provision for issue of bonus shares. Amendment or of articles for issue of bonus share. Just an example. Right? Because the bonus shares will be declared by the board only. But if there is no provision in the articles, you cannot issue bonus shares. Some member is suggesting that it amend the articles for issue of bonus shares. So if the requirement of 10% is satisfied, then they can bring a resolution. Right? Now, another for a statement. Now, a statement is your opinion on the subject matter already included in the notice. For example, subject is commencement of new business. A resolution has been placed in the notice for your opinion, for your consideration in the general meeting for voting at a commencement of the new business. And you know that it is the new business that is very, very dangerous. Here you can submit a statement. That is your opinion. The decision is based on the voting by the shareholders. Right. But you can submit this statement only if you are eligible. Every person cannot submit their opinion. Is this clear? What is the difference between the resolution and the statement? Okay. Now, when resolution is submitted, resolution submit at least 6 weeks before general meeting. If date of general meeting is not decided when resolution is submitted and subsequently general meeting is held within 6 weeks. The first line is saying submit at least 6 weeks in advance. But today somebody is submitting a resolution and then you decide to hold the meeting within next 1 month. What to do? With the 6 weeks are not there. For this is the provision. It is presumed that the resolution was submitted six weeks before. It is a presumption. It means you cannot avoid the circulation of resolution by holding the meeting earlier. The circulation is compulsory. Here you can add, if a resolution is submitted, then circulation is a compulsory. Noted? Why not? You can still circulate before 6 weeks also. Yes, enough for exam. That is the purpose I give you on the board. Otherwise, I can also discuss simply and go ahead. Okay. Now, this is about the resolution. As far as statement is concerned, relates to any subject matter already included in the notice of general meeting circulated by the company. What Nikhat is saying for classes you have given on 148 section remaining. Not clear. What do you want to say? Anyway, so this statement is in relation to the subject matter already included in the notice which is circulated. Number two, should be submitted at least 2 weeks before general meeting. Number three, if company obtains approval of central government, then it need not be circulated. So this is a line which is not there in relation to resolution. Resolution has to be circulated. A statement may or may not be. So if the approval of central government is not taken, that is also compulsory. Yes, Priti, this was a problem, but earlier in the when the companies in 1956 was there, I have suffered number of times because of this kind of right. At that time, even one member was authorized to submit a resolution, and people used to come that this is the resolution. Either you take it, circulate, or you give me this much of money. But now the problem has already been taken care of because of requirement of 10%. Okay, this was practically a problem before every AGM. Central government approval is here. Earlier there was a CLB approval. Now central government approval is very easy. Submit a letter and get the approval. Earlier it was CLB, that was more problematic. Okay. So if company obtains the approval of the central government, then it need not be circulated. And why the government should allow that? Central government may authorize non-circulation where it finds it as misuse of statutory provisions. That's it. At least 6 weeks before. You can submit that 60 weeks before. Not a problem. Right. 90 days, 190 days, 290 days, everything is okay because 6 weeks is minimum. It is not the maximum. Central government generally means so you have to apply to the MCA, otherwise they write very clearly ROC. So in very few cases, the powers have been delegated to the ROC and regional director. So friends, these are the notes as far as section 111 are concerned. If you have any more questions, you can ask me. So we have got only 5 to 6 minutes left. We have to wind up at 10:45. Proposed for bonus shares by the directors where article does not have the power. Now a statement can be given by a member highlighting the issue, and the amendment of article can be taken at any time of the issue. See, this is only amending the article. So amendment of article does not create an obligation on the board of directors to recommend the bonus shares. But if the article do not have the provision for bonus shares, then members can certainly bring a provision that incorporate these provisions in the article. So tomorrow when the need is, articles are ready. That is just an example. There can be any other provision. Yes, directors in the capacity of members, they can appoint a proxy. Statement. No, if the government does not authorize, then circulation will be compulsory. Time is very, very less for going to the government, getting the approval, but practically that is done. I've seen that happening. So we go back to content portion. So this part is done, and now let's proceed further. Representation of president and governor. What does it mean? If the government is holding any investment in the company, that is registered in the name of president, and if the state government is holding any investment in the company, that is registered in the name of president. So that is not in their personal capacities. So whatever shareholding they have in the official capacity as the president or governor, for this they can appoint a representative. They can appoint any individual as the representative, and his presence will be taken as personal presence of the president or the governor. Right. And the representative can appoint a proxy. Here, the president of India, when the president of India is holding shares, when the central government is having any investment in the company, that is registered in the name of president, not in the capacity of individual, but only as the president. So name of individual will never come. Who is the shareholder? President of India. President of India means what? The central government is holding investment. Similarly, office of the governor. So it means the state government is holding the investment. So where central government or the state government is holding investments in the company, that is registered in the name of president and the governor, and these two people have the right to appoint a representative. So here it is, as his representative. So this representative is not a proxy, because this person is also having the right to appoint a proxy. Of course, only individual can appoint a proxy. But this is one exception. Another exception is the next section, where the body corporate can also do that. So president and governor, they can, PMO can hold shares. No, PMO cannot. Central government investment will only be in the name of president of India. PMO cannot. Individual appointed as a representative will have all the rights here. A person appointed to act under subsection 1 for the purpose of this act be deemed to be member and shall be entitled to exercise the same rights and powers, including the right to vote by proxy in postal ballot, as the president or governor would have done. Right? But you have to understand clearly that this is not in the individual capacity, this is purely in the official capacity. Same thing is there in the body corporate, that by resolution in the board, they can appoint somebody as a representative of the body corporate, and this representative will be the personal presence of the body corporate. So one individual, if he is acting for a multiple body corporates as a representative, then the presence of that individual will be taken as personal presence of that many number of bodies corporate for the purpose of quorum, and this person will also have a right to appoint a proxy. Because he is a representative, he is not a proxy. So he will also have a right to appoint a proxy. So we are already on 10:40 and 10:45. We have to wind up. And before that, I want to have some chat with you. So if you have any question, you can ask me now. So whatever we have done today, you can ask any question on that. We have two more classes. One is on 9th, another is on 11th. बोर्ड का कुछ नहीं लिख पाई, क्यों नहीं लिख पाई भाई, क्या दिक्कत आई? Till now अभी तक blank है. Now it is okay. 11th का login detail that will come. Should I leave the site? Okay, now you can write. Adjourn meetings. So what happens if the representative votes against the wishes of the government or the company or who has been appointed for the said vote? No, no, no. Voting is only once. Whatever is done, that is done. Nobody can change that later on. Homework is always there. Whatever you are discussing, read the entire material based on that. And then if you have any question, you can ask me on one-to-one basis personally. That is the problem actually. You cannot make, generally they are saying that you cannot make comments which can be seen by all. So can there be a statement of board meeting as well? No, in the board meeting there cannot be any statement. There the directors don't have a right to submit a resolution also. Penalties under each section need not be remembered. Wherever you think it is important, relevant, or the amount is higher, it is serious, there it can be. Like section 447, it is very, very important section, only penalty, but applicable at number of places. So be thorough as far as section 447 is concerned. Scrutinizers, when they submit the report, as soon as the voting is over, immediately they have to submit a report. Any more questions? Only 2 more minutes left. Or do we wind it up here? So the next section, actually, this is something very, very small section. This you can read on your own. What is ordinary resolution? What in the next class I will cover up this entire portion, and this general meeting portion I'll complete in the next meeting. And then last one that we will have, that will be about the board. Okay. Thank you very much. Thank you, everyone. In the next class, be here on time. Discipline makes the difference in the career. Thank you, everyone, for being with me for so much of time, giving your valuable time to me. Thank you. Thank you. More the people, more I enjoy. Thank you, friends. Bye. So I'm here until the session is put off by the institute. So till then I'm waiting. For last to close by 10:45. I've done. Nikat, can you hear? Bye.